So we're here in Boston, the capital of the state of Massachusetts. This is the Supreme Court building. So we're about to go in and provide service on behalf of the affected litigants here within the state of Massachusetts for this indictment by a grand jury issue. This is on behalf of the Stevens and the Everett families. So let's talk about information for just a moment. Let's understand what that is. So the concept is this: what California was putting out with when they developed that particular law for their inferior state statute. This is what they were conceiving. So let's say, for instance, a police officer pulls you over, searches your car, that it's a completely lawful search, and they find drugs within that car. Well, unfortunately, who is the accuser? Well, it's obviously the officer. He's the one that found it. He's the one that's making the accusation that you have broken the law. But if the officer is the accuser, the officer is the state. And so obviously they knew from Article 3 that in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. If the officer is the one making the accusation, then the state wouldn't have jurisdiction. So they had to create a new accuser in these instances. And so what they did was they said, okay, we're going to charge you by the information that we obtained. So today, someone will call up the police. They'll say that something happened to them, right? Those police will take that information, reduce it to writing on their own, and submit it as an affidavit to the court saying, okay, I present this following information as factual, truthful, and correct. And then the judge says, well, yeah, it looks like good probable cause. Go ahead and order the arrest. This was a way to bypass the existence of an accuser. Because the problem is that you cannot take that information and put it on the stand and cross-examine it. So your right to confront your accuser, protected under the Sixth Amendment, evaporates the moment that they use information as a charging instrument. Because in common law, an affidavit is considered truth because it's presented to the court and it creates what's called a irrefutable presumption of guilt. So an irrefutable presumption of guilt is that there's an accusation that's been made, but it's never been rebutted. And as a result of it never being rebutted, an accusation that goes unrebutted is truth, right? It's factual. And so they're presenting this information as fact to the court and saying this is factually correct, when most of the time it's not factually correct. Not only that, but you also have the right to confront your accusers, no matter what. So in the case of an irrefutable presumption of guilt, what happens is that the accused is presumed to be guilty based upon the mere fact of being charged with a crime. So someone says that you did something, you are then treated as though you're guilty. You're arrested, you're deprived of your liberty, you're put into jail. All these things are happening to you without ever finding you guilty of any crime, right? So your due process has been violated long before the state has taken on the obligation to find you guilty. And the reason why is because in the case of an irrefutable presumption of guilt, the burden of proof shifts from the prosecution onto the defendant, right? So no longer does the prosecutor have to prove that you're guilty beyond a reasonable doubt. Now, you as a defendant have to go out and collect evidence to prove that you're innocent. And this shift in the burden of proof, according to Blackstone, it occurs when there's a breakdown of due process and the system focuses on speed and efficiency as opposed to established procedures and processes. We have an absolute breakdown of due process that exists because states such as Massachusetts here has decided that they can direct their officers, right, their prosecutors, to be able to charge by way of information, not by indictment, as required by Clause 1 of Amendment 5 to the United States Constitution. So Clause 1 of Amendment 5 says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That's clear. You got to have an indictment by a grand jury before arresting someone and holding them over for that crime. So instead, these prosecutors say, by their discretion, that they can disregard that requirement, that obligation that exists to them to use the proper charging instrument, and they can use their discretion abusively to charge them in a different manner by way of information. And so when the state creates that law, right, creates a law, its own alternative legislation, and then substitutes it for the provisions and guarantees of the Constitution, that would be unconstitutional. Because the crime of sedition means, it's defined as, the speaking or writing of words, such as law established, in order to cause disaffection of the Constitution to procure its alteration other than lawful manner. There's one way to change the Constitution, that can be found in the special amendment procedure of Article 5. And it is not done by way of a state imposing its will upon the rest of the nation, or by judicial, executive, or legislative fiat. It must be done by an authentic act of people. And until that occurs, those requirements and obligations, they are immovable, infallible, and they are sacredly obligatory upon all, individually and collectively. So those guarantees that are in the Constitution are guaranteed because the officers, such as the prosecutor in the state of Massachusetts, have an obligation to ensure that they provide it. When they breach their obligation, that results in violation of your right. So here in the state of Massachusetts, Every single time that prosecuting attorney decides to rely upon that inferior state law to deprive a person of a right guaranteed by the Constitution, they commit a crime, felony. It's deprivation of rights under color of law, Title 18, subsection 242, which states any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, commits that crime. So these are per se crimes, meaning that we don't have to prove that they intended to breach that obligation simply by virtue of the breach. All elements of crime have been met because their willfulness and knowledge derives from the promises they make. So we're going to go in here now. We're going to go in. We're going to provide a notice to the Supreme Court of the state of Massachusetts, letting them know that your judicial officers are committing multiple crimes that lead to the punishment of death as prescribed by law, and that we are going to ask them to take action to protect the people of the state of Massachusetts from crimes that are being committed by their own agents. And we're going to see what they're going to do about it. Because if they choose to do nothing, then that means that they're going to become complicit in it because of their negligence. They have a duty and responsibility to make sure that their workers work in compliance with the law. And if they don't, then they themselves are sanctioning this criminal act. So we have to change it. We got to make sure it gets corrected. And if they're unwilling to do it, then we're going to take it next level. So ball us in. God bless. Thank you so much. Have a great day. Hi, how are you? Are you clerk of the court, deputy clerk, or?
This is the clerk of the Supreme Judicial Court. How can I help
The Supreme Court, right?
you?
Okay. So we have ongoing federal litigation at the United States Supreme Court. We need to provide notice to the state of Massachusetts. You guys are not enjoined in the litigation. It's actually against the state of Washington, but we need to make sure that the justices in the state is made aware of the issues so that we can hopefully get resolution. We can direct the judicial officers within the state of Massachusetts to act in a lawful, constitutional manner. And so here we have the certificate of service on the front. I handwrite them. My contact information is on the inside here. We have 2 affidavits from the Stevens and the Everett family. She's filling it on me. It has nothing to do with you. It's for my own safety. So there's two affidavits signed by affected parties here within the state. All we need is just this to go to the justices, provide notice so that we can correct the actions of the judicial officers here within the state. I'm sorry?
Is this a new case?
So it's a case that's 9 years old against the state of Washington, but so when a state enacts its own alternative legislation and substitutes them for the provisions and guarantees of the Constitution, that would be unconstitutional. So when the state of Massachusetts enacted its legislation that permitted prosecuting attorneys to charge by way of information, not by indictment, in violation of Clause 1, Amendment 5, then that is.
So this is a new case in the Supreme Judicial Court.
United States Supreme Court, not state Supreme Court. We are beyond the states. We are in the United States Supreme Court. And so what we need is the justices here within the state of Massachusetts to take a look at this. If they agree with it, then hopefully they will direct the judicial officers within the state of Massachusetts to act in a lawful, constitutional manner, and we can avoid any further litigation with the state of Massachusetts.
Okay, hold on one moment.
Okay?
You can just take a seat over there. We're just waiting for one of the assistant clerks to come down. They're in a meeting right now.
Okay. Is it going to be very long? Because we got to get back to Rhode Island and serve Rhode
I
Island.
don't know how long it's going to be.
Okay. What's your name, ma'am?
My name's Courtney.
Okay. And what?
Why are you filming?
This is for my protection. So we've been through.
Well, you're not supposed to film in this office.
Yeah, so I operate at the federal level. The Supreme Court has permitted it to occur. We can certainly have a discussion with the Attorney General here in the state, but there's no reasonable expectation of privacy in the public domain, and that was a determination by the United States Supreme Court just 2 years ago. Anyway, we're good. This has been served. We delivered it here.
It's an assistant clerk needs to take it in because technically it's a new case in this
No,
court.
it has nothing to do with this court. This is not a case. We're not.
I can't speak with you. You need to have a seat over there.
So okay. Thank you. This is not a new action. This is a notice, and the notice will be provided.
Text to see if we can have somebody come down. Like I said, she told you they are in a meeting with the Chief Justice. If you want to take a seat, that's more than welcome. But unfortunately, ma'am, you have to leave. We don't allow calls.
Yeah. And this has been served. So we're good. This notice has been served. So thank you guys so much.
It's not notice, and I'm not.
Oh no. Well, you don't have a choice in that. Oh, no, it doesn't have to be stamped in because this is a notice. So a notice is not a case. God bless. Thank you so much. What was your name, ma'am? Oh, you don't have a name. Okay. Thank you so much, guys. Service has been provided in the state of Massachusetts on behalf of the Stevens and Everett family for the crimes of deprivation rights and club law, conspiracy to deprive of rights, kidnapping, and other crimes ascertainable by the evidence on the record. It was placed on the counter. They were representatives. They received it. God bless. Good afternoon. Moments ago, we provided service on the Massachusetts State Supreme Court on behalf of the Everett and the Stevens families here for the crimes, deprivation of rights and club law, conspiracy to deprive of rights, kidnapping, and other crimes ascertainable by the evidence on the record. So when the state of Massachusetts chose to enact its own alternative legislation, which permits the prosecuting attorney to charge by way of information not by indictment as required by Clause 1 of Amendment 5 to the United States Constitution, that is a seditious act. Sedition is defined as speaking or writing of words, such as law established, in order to cause disaffection of the Constitution to procure its alteration other than lawful manner. There's one way to change the Constitution that can be found within the special amending procedure of Article 5, and it's not by way of a state enacting its own laws and imposing its will upon the rest of the nation. We must ensure that the process of correcting or amending the Constitution is in compliance with the people's will. And until the people vote by suffrage and choose by an authentic act of the people to change the way in which we do business here, then those requirements and those obligations are obligated to the public officials. So prosecutors, they swear that they will support and defend the Constitution of the United States. Their oath and obligations come from that Constitution. When they fail to comply with that oath, then they've committed a crime. It's the crime of perjury, as well as also the crime of deprivation of rights under color of law. So that's Title 18, subsection 2.2. It says that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution, commits that crime. So these prosecutors, they need to understand that their obligations are to the Constitution of the United States, not to an inferior state statute. So when the state creates a law that directs their agents to act in a manner contrary to the Constitution, it is their responsibility to ensure that they follow the proper procedures and not simply be led astray by whatever the state tells them to do. The states do not have the power to enact their own laws, and they're in conflict with the Constitution of the United States, and then subject the people to anything contrary to what we've established, put into place, and ratified. So we need to ask the Supreme Court of the state of Massachusetts right now to step up and discharge the duties of their office, fulfill the promise they made to the people of the state of Massachusetts, and hold criminals accountable for the crimes they commit. It really doesn't matter who they are, what title they hold, or what position or office they fill. Criminals are criminals, and criminals have to do with transgress the law. It doesn't matter if it's the Constitution or if it's a state statute. If you transgress the law, you are a criminal. So we need to make sure that these public officials act in a lawful manner out of love, faith, and obedience in law, respect for the will of the people and what they've established. And if they do not do that, then they're criminals, and criminals do not have a position of leadership here in America. So we're going to ask the Supreme Court to step up, discharge the duties of their office, fulfill the promise they made to the people of the state of Massachusetts, and hold these criminals accountable for the crimes they commit, and even if they do work for them. So thank you so much. God bless, and we got 2 more states to go.